Hello, everyone. This is Tom Fox. I'm the Compliance Evangelist, and I'd like to welcome you to episode 380 of the FCPA Compliance Report. Today, I have with me Laura Perkins. Laura is a partner at Hughes Hubbard Reed, and she was formerly with the FCPA Unit in the fraud section of the Department of Justice up until September of last year. She visits with us today about the always tricky question of when should a company consider self-disclosure, what information should be in its initial self-disclosure to the Department of Justice, the investigation plan should be presented to the Department of Justice, how and when should remediation begin, and how much information does the government want to know or have in this area during the pendency of an investigation, and when should a company present information to the Department of Justice that it believes the matter should come to a conclusion. For every compliance practitioner, these are obviously tricky questions that you may have to face. So I think you will find this podcast particularly enlightening, interesting, and something that you can use going forward. The FCPA Compliance Report is a part of the Compliance Podcast Network. Hello, everyone. This is Tom Fox, back for another episode, and you're in for a real treat today because we have Laura Perkins with Hughes Hubbard Reed to visit with us about several issues around investigations and enforcement actions. Laura was with the Department of Justice Fraud Section in the FCPA Unit for 10 years, and now she's out in private practice. I had the chance to meet her at a conference in D.C., and she was incredibly informative and very helpful to folks really practicing compliance. So Laura, with that somewhat long-winded introduction, thank you for taking the time to visit with us today.
Well, thank you, and thank you for the kind introduction. I appreciate it.
So Laura, there's a lot of people who, particularly compliance practitioners, who don't understand kind of what their role is and what they need to do after they have self-disclosed or come in front of the Department of Justice for an investigation. They may understand, they have obviously had counsel advising them, FCPA counsel, but a lot of people don't know what they should be doing in terms of not only the investigative part, but the remediation part. And that's really what I want to explore with you today. What's the role of the compliance practitioner in all of this? So maybe I could ask, what information from your perspective would you advise to be in the initial self-disclosure?
Well, I think it depends on the status of the company's investigation at the time they make the determination to self-disclose. I do think obviously it's an important thing for a company to understand kind of what will be expected of it, what type of information it will be expected to give, even as they're deciding whether or not to self-disclose. But as far as kind of what the company should expect or sort of be prepared to disclose in that initial disclosure, I mean, the company should be prepared to go in with facts about what they understand the potential misconduct to be at that point in time. They should be prepared to either offer up or answer questions about, how did this come to your attention? What is the nature of the misconduct? What's the amount of any potential bribes? Things, very factual oriented questions about the misconduct. There'll be questions where the company should be prepared to speak to any jurisdictional facts that would help the department to determine whether it does or does not have jurisdiction over the misconduct, how sort of widespread the misconduct was at the company, and other points that go to sort of the facts of the potential misconduct. There will also be, questions, and again, the company should be prepared to provide information to the department about the status of its investigation. Again, how did this come to the company's attention? What has the company done, between learning of it and coming to the department to investigate the misconduct and hopefully to, if the company has an understanding of sort of how it's happening, what steps have they put in place immediately to stop misconduct if it was an ongoing issue. There'll be a variety of other questions, again, depending on the facts that are disclosed at that meeting. But those are sort of the general types of information a company should be prepared to provide to the department. And I would say one sort of tip I would give to companies is, particularly in cases where there is very questionable U.S. jurisdiction or very small misconduct, to highlight sort of that fact for the government, to go in and say, at most we're talking $5,000 of bribes and a profit of, $50,000. Those sorts of things will help the government determine whether the investigation is worth its resources. So those are additional things that the company should have ready to point out to the government.
So another question I'm often asked is about the internal investigation, because I think many compliance practitioners have, if not an understanding, at least an idea of what they should do in internal investigation, but they don't understand how that would interact or work with a government when there's a self-disclosure investigation. So what really should a company be prepared to do in terms of disclosing and adapting its investigation in consultation with the DOJ?
I think that it benefits both the company and the department to have open lines of communication about steps the company is envisioning taking that may have any kind of impact on a government investigation. So, for example, if the company is envisioning taking disciplinary measures against employees, that is something that the government appreciates learning in advance of those measures being taken, because some of the steps that a company takes, let's say terminating, for example, a foreign-based employee, that can have the effect of making that employee more difficult for the government to investigate. So those sorts of things, which would be sort of within a compliance officer's realm during the investigation, to sort of look at and think about what the appropriate disciplinary measures are for individuals involved in the misconduct. Those are the types of things that are important to share with the government in advance of taking those measures.
One of the things I've heard several white-collar practitioners say that when they initially self-disclose and present an investigation plan to the government, literally, if not the first question, one of the first questions is always, have you secured the documents? Is it that important to the government that documents or other forms of communications be secured?
Absolutely. Because the government is going to want the company to share those documents with the government. That's incredibly useful evidence in any investigation, in any future prosecution. So it is of primary importance for a company to ensure that it secures documents, both hard copy and electronic. And I think that the recent FCPA corporate enforcement policy actually touches on this in certain ways, including by saying that, not just in the context of an investigation, but that the government, will look at whether or not companies have in place regular policies to retain documents and to discourage employees from using apps like WhatsApp, where sort of the communication instantly disappears.
So the next area I wanted to explore with you is the remediation phase. And years ago, when I first started practicing, many companies would not start their remediation until after the resolution of the enforcement action. That has now changed, and most, I think all companies start remediation during the pendency of the investigation. How should a company work with the department in terms of the remediation? Should there be that type of open communication and dialogue that you've talked about already?
I think that, whenever a company is cooperating, there should always be open communication and dialogue. It may be that the company tells the government things and the government doesn't respond, doesn't react, and in some instances may not care. But it is, I think, important for the company to maintain those open lines, because there may be things that the government knows that the company doesn't know. And, if the company takes certain steps that it may think, based on its knowledge, the government won't care about, that the government does in fact care about. So those open lines of communication are very important, both from an investigative perspective, sort of as the company goes and investigates, but also, to your point, to the remediation perspective as well. And like I pointed out, I think one of the main areas where it's important in the remediation area is employee discipline. That is an important area for the government and the company to be in close communications, because that's an area where a company can get itself in some trouble with the government as far as cooperation credit if it takes certain disciplinary steps without sort of letting the government know first, that end up getting in the way of the government's investigation.
So in terms of the, I guess another area that really befuddles a lot of compliance practitioners is I guess it would be, when is enough, but it's more from the company's perspective. When are you ready to tell the government that you would like to open resolution discussions? Is that something that actually just sort of seems to happen organically, or is there a point that you think companies should at least consider that option?
This, in my experience, has been somewhat case specific as far as when a company makes that determination. But by and large, it is when the company feels like it has gotten its arms around the misconduct and is in a position to say to the government, here's what we think the conduct was. Here's what we think the profit or loss, usually profit, is from the misconduct. Here's who we think was involved, and here's what we think an appropriate resolution would look like. So typically, most companies, I think, feel like they need to get to the point where they really understand the conduct well enough to make that approach to the government. And it's also, but I think it's important that the company not over-investigate before going to the government. There will be things in any investigation where a company is not able to tie down a particular fact here or there. And if the company continues trying to nail down every single little fact, that one will cost the company an unnecessary amount of money, but will also slow down any resolution and is probably not necessary in the long run. And so, again, this is where open lines of communication are very helpful. If a company communicates to the government, we think we're basically done with our investigation, and we'd like to come in and present to you on what we think the appropriate resolution is. But there are one or two little things, and the company can explain what those little things are that they haven't been able to pin down, and see whether it matters in the government's view for the company to actually find out those remaining facts. Often the government doesn't need those things pinned down, and so that communication with the government on that fact will end up saving the company time and money, and will move the resolution faster.
So in another area that I think many compliance practitioners really have no appreciation or understanding is how do you come to a final settlement amount if there's a fine or penalty? Is that something that's through negotiation? Obviously, the sentencing guidelines will give you factors to put into a calculation. There'll be a range with then a potential decrease from the minimum range if you've self-disclosed, if you've cooperated extensively and or remediated extensively. But how does that process work with the government?
like you said, the fines in FCPA cases are driven by the United States sentencing guidelines, which is fairly formulaic calculation once you enter all of the sort of relevant facts. And that's where there is discussion and differences of views sometimes between the government and the company. So while I wouldn't say that the fine is really the result of a negotiation, there are significant discussions that happen between the company and the government as to what the facts are that should drive that sentencing guidelines calculation. In most cases, the discussion will begin with the company coming in and presenting on usually the largest driver, which is the profit or the bribe amount for any given resolution. And so the company will come in, present on what it believes the profit to have been, and the government will test those numbers, and there will be sometimes there's agreement right away, often there isn't, as to kind of what numbers should be included, what deductions shouldn't be allowed, and those sorts of discussions as to what that ultimate number should be. There are also discussions on other factual issues that drive the sentencing guidelines calculations, and so it will be, the company often comes in and presents on what it thinks those facts are, and the government will respond, and sometimes it will end after that, and sometimes there will be a series of discussions about what those relevant facts are.
I guess, Laura, I'm getting the real sense throughout this podcast that if there's a theme, it's open lines of communication and dialogue, really throughout the entire process. Would that be a fair statement?
Absolutely. In all of the cases that I handled and that I supervised at the department, the open lines of communication I found to be very helpful for not just me as a prosecutor, but I think ultimately really benefited the company, because the more information the government has, the more quickly both a resolution can be reached and the government's investigation can be closed, and that's good for the company as well.
There, on the remediation, we've seen many companies sustain a FCPA enforcement action, not be required to have a monitor, yet some continued reporting to the government. Typically, it seems to be annually there would be a report. Could you explain not really the monitor part in that, but if there is no monitor, what's the purpose of the continued reporting during the pendency of a resolution document?
The purpose of the continued reporting is to make sure that the company is abiding by the compliance obligations in either a non-prosecution agreement or a deferred prosecution agreement. Because even if a monitor is not imposed in connection with the resolution, there are compliance obligations undertaken by the company, and in the absence of a monitor, the best way for the government to come to an understanding as to whether or not the company is meeting those obligations is to have the company report on the progress and status of its compliance efforts and its compliance program. And so companies are required in those agreements to submit, like you said, annually, and an overview and assessment of the effectiveness of their compliance program.
Well, Laura, unfortunately, we're near the end of our time, but this has been just a fascinating exploration. I've been visiting with Laura Perkins, partner at Hughes Hubbard Reed, and former part of the Department of Justice's FCPA Practices Unit in the fraud section. I did want to ask if anyone wanted to follow up with you on anything that we've talked about in this podcast, Laura. Could they do so, and if so, how?
Absolutely. My contact information is all on the firm's website. I'm in the directory, and so there's email and phone numbers there. So if anyone has questions about any of this, please feel free to look me up there and reach out.
Laura, thanks again. This has been very instructive for me.
Great. Well, thank you very much. I appreciate it.
Hello, everyone. This is Tom Fox again. I'd like to thank you for listening to this episode of the FCPA Compliance Report. If you have any questions, you can email me at tfox@tfoxlaw.com. If you have listened to this podcast on iTunes, I would greatly appreciate it if you would rate our podcast, as it would help in our rankings and help get the word out about the longest-running podcast in compliance. Also, please check out my new book, The Complete Compliance Handbook, which is available for pre-sale on my website, www.fcpacompliancereport.com. Thank you again for joining me, and I hope you'll join me again next week for another episode of the FCPA Compliance Report. The FCPA Compliance Report is a part of the Compliance Podcast Network.